Here's a common situation. An employee feels like he's being treated unfairly or like he's being harassed at work by his supervisor or a manager. Because maybe his supervisor is yelling at him or cussing at him every day. Or maybe his supervisor is micromanaging his work for no reason while not doing that to other employees. Or maybe that supervisor keeps issuing unfavorable and unfair performance reviews to him over and over, which creates a lot of stress on that employee. So that employee goes to his HR department and gets no help. He feels helpless, he feels upset, he feels angry, so he goes to an attorney in order to find out whether he has a reason to sue his employer or his supervisor individually or both. He presents all the facts of what's going on at work and to the attorney, and that lawyer tells him, look, what's going on with you at work seems to be very unfair, very wrong, and very hurtful. However, in the absence of evidence of unlawful discrimination, unlawful retaliation, or unlawful harassment because of you're a member of protected class or because you engaged in a protected activity, there is not much that can be done legally, because a case cannot be filed just because you're treated unfairly or hurtfully. There has to be a specific violation of a specific law or a statute. So the employee tells the attorney, well, I just want my supervisor who makes my life so difficult at work to be held accountable. I just want him to pay for what he did. And that's where the problem is. It's important for every employee in this kind of situation to know that the law does not provide for that kind of remedy. The only thing you can get through a lawsuit is compensation, whether it's a settlement or whether it's an award in court or an arbitration. The problem and the limitations of civil lawsuits is that no one can force your employer or your supervisor to either be nice to you or to have your employer fire that supervisor, although often that would be a good thing for the employer to do, or to have that supervisor or that harasser apologize to you or acknowledge that they treated you wrongly and that they shouldn't have done that. Even in cases when substantial settlements are paid out by employers, and even in cases where big judgments are awarded by juries to particular victims of discrimination and harassment, the defendants or the individual supervisors who are at fault are still not apologizing. They're still not acknowledging that they did anything wrong. In fact, it's very common, or it's always the practice in just about any employment case that settles for any amount of money. It's a very common practice for an employer to require the employee, the plaintiff, to sign the paperwork that says that the employer doesn't admit any liability, that they haven't done anything wrong, that you release all your claims, and so forth. So it's important that you, as a plaintiff, as a potential plaintiff, or as a current plaintiff in any wrongful termination, discrimination, or retaliation case, it's important that you're aware of these limitations. What you can get in your case is compensation, assuming that you have a viable claim and assuming that you can show damages such as past wage loss, future wage loss, emotional distress, and so forth. No court, no jury, no arbitrator can force the employer to apologize or to be nicer to you or to improve your relationships with your coworkers or with your management. Understanding this will help you make the right choice or the right decisions when deciding whether or not to file a lawsuit against a particular employer or a supervisor, and why you should or should not do that. Thank you.